good afternoon or good morning for some of you. Thank you for joining us today. We have a very special presentation and panel, and I think we're going to have some fun. This is nuts and bolts of commencing a commercial receivership case. It's episode 1 of the Financial Poise State Court Receivership series. You can read more about financial poise on slide 28 of this presentation. Today we have some incredible, amazing, talented panelists. We've got Emily Cantwell from Lathrop GPM. We have Mark Silverman from Troutman, Pepper & Locke, and Paige Bartingham from Blank Rome LLP. My name is Matthew Brash of New Point Advisors Corporation, and I will be your moderator. You'll be able to see our names on slide 6, and you can read our bios on slides 20 through 23. Neither Financial Poise nor we intend this to be an infomercial, so you don't have to listen to me read everyone's bios. But if you want more information, please look at the slides in the bio section on 20 through 23 of the slide presentation. I'll try to call your attention to the slides whenever relevant as we go through this, but this is supposed to be more of an open forum and discussion with our panelists. And for those that are watching or participating, feel free to ask questions. We're going to be bouncing back and forth between a number of topics and discussion items. I would also like to take a moment to thank our co-producers, Financial Poise and Daily DAC, as well as the National Law Review. Also like to pay quick attention to our sponsors, Max Asset. You can read about the information between Financial Poise, Max Asset, the National Law Review on slides 24 through 28. The last thing before we begin on slide 5 is a disclaimer. You are not our clients. We are not your lawyers. What we do here today is for your general education and not for you to act on without appropriate advice. So without further ado, we are going to get started here. I'd like to start with Mr. Mark Silverman and discuss really one of the beginning questions about commencing a receivership case is who contacts you about commencing a receivership and what is the nature of that discussion?
Absolutely. So hi, Mark Silverman, Troutman, Pepper & Locke, resident here in Chicago. So who contacts me? It's usually our wonderful clients at the lender saying, hey, we've got an issue. It's in one of these miraculous office buildings, hotel, industrial complex, multifamily building, or other asset that is in default or trending towards default. In that correspondence, typically we get conflict information and the name of a receiver or several receivers that we should be talking to and potentially evaluating to work with. That's one way that this comes to us. Another way is that our wonderful clients come to us on the receivership side and say, hi, we've just been engaged by XYZ lender to come in and be the receiver of a property, and we need legal advice, guidance, and counsel surrounding the actual receivership. So those are kind of the two avenues that we typically get involved with these types of cases.
Thank you, Mark. What kind of, there's all different types of collateral that is basically out there. Paige, is there a contractual or statutory basis for appointing a receiver, like the loan agreements, mortgages, whether it's real estate versus C&I, if you don't mind going into that?
Sure. Matt, it's actually a little bit of both. So you have one question is, does your loan agreement provide for the appointment of receiver? Almost all mortgages do. They should. Hopefully everyone you're looking at does. And then if we're looking at, if your loan document does, and you want to have a receivership in state court, there's different state laws for every single state as to an appointment of a receiver. But in Illinois here, if your loan document sets forth that you have the right to appoint a receiver, and you have a reasonable probability of success on having a receiver appointed, which is pretty easy. If you have a default, you have a reasonable probability of success. Under the Illinois Mortgage Foreclosure Act, you have the ability to have a receiver appointed. There is an exception for good cause. There's not a lot of case law on what exactly you have to do to show good cause. It's more about what you don't have to show. There's more case law on what you don't need to get there. If you don't have to allege fraud, you don't have to allege mismanagement, you don't have to allege waste. You just have to allege that you need a receiver. And let the opposing party try to get to a different level of good cause. There's also receivers for equity. So if your loan document does not have a contractual point for a receiver, I was in court just Monday of this week where I had a mortgage with a borrower where we had language for appointment of receiver, but I also wanted a receiver over the operator of that property who was not a borrower under my mortgage loan agreement, but was a guarantor. I had a judgment against the guarantor, and the state court judge gave me a receiver based on principles of equity. And then if you go into federal court, you also are looking more along the lines of equity, and you have to meet the requirements for an injunction. So there are many, many different ways you can get to a receiver. Each state is a little bit different. Here in Illinois, it's very much, do you have it in your loan document? Do you have the probability of success? Or do you need to look at equity?
Emily, can you tell us a little bit about on the kind of the same topic, being out of Missouri and some of those jurisdictions out there? Do you see very common anything that's different than what you've seen in perhaps in the state of Illinois or at other jurisdictions?
Yeah, I mean, so Paige is right. Every state, certainly, or most states have their own, independent state court receivership acts, and those are all, perhaps related but not identical to one another. So, for example, I sit in St. Louis, Missouri, and so we, when I go to state court here in Missouri, I'm operating under the Missouri Commercial Receivership Act, or MICRA as it's sometimes called. And so what I will see is all of the reasons that both Paige or Mark already articulated as to why a receivership might get kicked off. But the Receivership Act that went into place in Missouri in 2017 gives, it's upwards of maybe 12 or 14 different reasons as to why a receiver can be appointed. And that can be something, as simple as a creditor isn't receiving the loan servicing that the creditor should be receiving. And that can be a typical, lender, or somebody that would be something different than, your typical bank or something. But to Paige's point, it doesn't, in Missouri, at least, it doesn't always have to be in writing. And many times it isn't, that you'll be looking at a situation where there isn't a document that allows for a receiver, and the court, for any number of the enumerated reasons in the act, equity certainly being one of them, judgments being another, will seek to appoint a receiver.
And one piece on this, just to reiterate what Paige mentioned, is on this good cause shown in Illinois. The amount of times that we see borrowers come in and just say something is good cause is fairly significant. The issue is that the case law here is very clear that it needs to be an imminent refinancing. Seems to be the only true exception that can be put forward. But to be an imminent refinancing, it needs to be more than a term sheet. So we have lots of folks come in and say, hey, we have an imminent refinancing, and we've talked to a dozen banks and they all told us that they're going to give us term sheets and we're going to be able to refinance this. It's going to close in 30, 60, 90, 120, maybe a year. Please don't put in a receiver. It will kill my ability to refinance. To that, I say, no, that's not sufficient. That isn't good cause, and a receiver shall be appointed absent a finding of good cause. So again, even in the context of a term sheet, that's still not loan documents. That still doesn't include a closing date. I still don't think that passes muster. And we've prevailed time and time again, trying to bat away that argument. I should also mention, we're always on the creditor side. So from that standpoint, I do have a slight bend towards how I view things, but at least just to put that out there.
That's a good thing that you brought up, because I see all the time being in court, and as being a receiver, you have at the 11th hour, a borrower defendant show up with a piece of paper in their hand saying that there's something there. There's a there, and that this can all be done and end in 21, 28 days. Mark, you brought up a good point that more times than not, it's fluff, and that you guys you'll prevail. I guess, Paige and Emily, have you guys seen it where the judge does give a borrower defendant that kind of time? And, what is usually your arguments and your push to say, like, this is just, let's maybe go down mutual paths here, and the receiver gets appointed and they have something, we're happy to talk. I'm kind of curious what you've seen in that situation.
I really fall into Mark's camp on this. I represent mostly lenders. And so mostly we are seeking the receiver and have good reasons to seek the receiver. I do a lot of healthcare receiverships where it's, there's imminent cause to have a receiver appointed immediately. So I've actually never had a receiver request denied in the healthcare space, as long as you have a default under the loan and you have the rights to do it. So I have not seen the good cause be met by any defendant.
Yeah, and for me, Missouri, the act honestly, it gives the court so much discretion that I think the courts, especially those judges that see receiverships more often than some of the jurisdictions that perhaps are more unfamiliar with receiverships, the judges understand that they have so much power when a receiver is in place, that this idea that a receivership is only going to be brought to them when there are good grounds to do it, coupled with the fact that they have so much discretion and really are the gatekeeper for any of the decisions that the receiver is ultimately going to make, I think gives courts a lot of comfort, such that I've never actually seen a receivership request be denied either. But I think part of that is that the lawyers who are bringing the request to have a receiver appointed are doing so judiciously, meaning they're not bringing them when there aren't certainly grounds to do that. And we'll talk about later, I think, in this session, when is it a good idea and when maybe is it not time yet, or the facts certainly don't fit the situation. But I think that is part of what helps all of us kind of have the same answer of, we generally just see them being granted these requests because they're being brought in appropriate circumstances.
Not the closest I've ever come on one being overturned based on good cause is when a borrower came in with a variety of term sheets. All of the term sheets had the exact amount of debt. They had interest rates, they had term, they had all of this. The way that we were able to circumvent this is that each of those term sheets included the bank savings language that says this remains subject to credit underwriting, this remains subject to final loan documentation, every other caveat there. That paragraph in and of itself sealed the deal on our prevailing on getting the receiver appointed because it wasn't imminent. It could all blow up with any of those lenders, subject to underwriting, never getting to terms on negotiated loan documents, et cetera. So I do think it happens, and you can get close to that line where a judge is going to say, wait a second, give them a minute, let's see if we can get this done. But that was, we had signed term sheets and the judge still allowed the receiver to be appointed.
Excellent. Emily, what are some red flags? So when you've got clients that are discussing a potential receivership and filing receivership, what are some red flags that in those discussions that kind of set off that light bulb of, oh, we got to be pushing on this receivership?
Yeah, certainly when you start to see defaults or loan servicing that's no longer occurring, that's going to typically be the number one kind of ding, ding, ding that the client is going to start to pay attention to, when the payments that had otherwise been, every 30 days or 45 days or whatever the payment term is, suddenly are delayed, or certainly if they're stopped. That's going to be obviously one to really tip off the client. If the client, is worried for good reason that there might be some inappropriate management, mismanagement, fraud, siphoning of assets, where there's some concern that maybe whatever their security is otherwise not going to be there, is going to be watered down. I think that would be something to look at. But on the flip side, I think it's also very important to talk to your clients and say, look, once a receiver is appointed, the receiver doesn't work for you. The receiver works for the court, and the receiver is an arm of the court. So we need to make sure that our hands are clean and that our ducks are in a row, because the receiver is going to have the ability, presumably, if you submit a nice receiver order, to have essentially unfettered access to some of this information. And so you better make sure that your house is in good working order if you are wanting to get that receiver in there.
Excellent. Paige, have you had scenarios in which you've had to talk clients out of filing a receivership? Obviously we as, attorneys, consultants here, and we don't like turning away work perhaps, but it's in the best interest for our clients to kind of save them from themselves perhaps in situations. Do you mind going into situations or scenarios in which you've had to tell potential clients or clients in themselves saying, hey, this is probably not the right idea? And what some examples or thoughts on that?
Sure. So it definitely, at the beginning, when your client comes to you and says they are thinking of filing receivership, there's a lot to think about. It's not the best fit for every situation. And we really need to think about, what do you want to accomplish? Do you just want to foreclose and sell the real property? Sure, that's easy. You can do that in receivership and not take property. But do you have a business that you need to continue the operations for during that receivership on the property? Do you need to remove management? If you need to do those things, we need to look at the business itself. Is there cash flow? Is the business able to support itself? Is that money coming in? Will you be able to have control over it? The receiver should, but at times it's being diverted. It's going to take time to get the receiver's hands around it. The lender may need to fund. And so the lender needs to think about, is this a business that's worthwhile putting the money into? You don't want to start funding and end up funding more than your actual collateral is worth at the end of the day. And you need to think about the timeline. Is this something that we can put in, we can sell quickly, or are we going to have to manage it for a long time? What's the cost? So the cost is really a big issue that needs a lot of diligence up front. It really, and sometimes that's difficult because the borrower isn't really working with you to give financials and isn't giving you the full picture. And so that can be a difficult exercise at the beginning, but it's absolutely necessary, and has had us back away from actually filing. And sometimes other alternatives are better for those circumstances. The other issue you need to think about is, what's your jurisdiction? Are you going to get into court right away to get your receiver? Or do you need a receiver on an emergency basis? There's some courts. I had one court that took 3 months to get our receiver order. In that court, and we felt it was an emergency. It wasn't to that judge, but in that jurisdiction, it wasn't going to be the right resolution for that issue. Also, does the state that you're filing have a robust receivership statute or not? Are you really working on terms of equity? Do they fit with your facts? It's something we talk about a lot. And then, what does your current jurisdiction do for picking the receiver, right? Do they pick the receiver off their list? Is there a specific list? The city of New York has a specific list you have to be on to be appointed a receiver in New York. That might not work for all situations. So you have to decide if that works for the particular case. As I mentioned, I do a lot of healthcare work. Working from a list of people who do a really great job at managing hotels or real property doesn't work for the healthcare area. So you have to work with that situation. And then another thing that Emily mentioned earlier is your house in order, right? Are all of your liens properly recorded? Do you have a lien on all of the assets, or do you have other junior creditors that you need to deal with, or senior creditors that you need to deal with? And those senior creditors, you don't want to file if you're only going to be benefiting them. So there's a lot that has to go into the decision to file. And as we had mentioned earlier, that's probably why there's a high success rate in appointing receivers, because you do all that diligence up front to see if it makes sense or not.
How common, Paige, do you see emergency filings for the appointment of a receiver? And do they more times than not get appointed or not? Or, I mean, you hear about emergency filings, or like I've gotten calls about emergency filings, and then I talk to, excellent attorneys like you guys, and we're like, well, this judge may not think of it as an emergency. I mean, Paige and the rest of you, from an emergency standpoint, have you seen quite a bit of those, and do they get through a lot, or is a lot of times it's like, whoa, slow down, like, I don't think this is considered an emergency?
So from the healthcare standpoint, it's always an emergency. So
Yep.
Every single motion I file for a receiver is on an emergency basis. And I will tell you, I've had courts that have granted it when we walked into the courthouse to file it. It was granted right there on an ex parte basis.
Wow.
That was an extreme, but it was done. And I've had the other side where it took 3 months for our emergency hearing on that. Typically, it's 1 to 2 days. The judge gets you in as soon as possible. They want to protect the health and welfare. When you're not dealing with healthcare, it usually takes longer. It's not seen as much as an emergency. And on the emergency front, sometimes as well, the judge may say, I'm going to grant it right now, but we'll have a final hearing. So they may kick some of the issues if they're not ready to do it right then and there, particularly if you don't have service on the defendant to be present at the hearing. But they do grant them in the healthcare space ex parte very often.
That makes total sense. Emily or Mark?
Yeah, so I mean, I'll add my flavor of being, in St. Louis and in Missouri. So to Paige's point, and I think these are all very related about what's an emergency and what's not. deciding when to file a receiver, especially in Missouri, where you might have some judges in outstate Missouri who just don't see receiverships very often, and might not be as well versed. That's something that you have to think about because, just like for all of us, if it's a new topic, it's something that they are going to want to and need to learn about or otherwise be educated about. And that should be something that should go into the decision tree. What that also means is perhaps what our clients believe to be an emergency might not be an emergency to a judge no matter where they sit, because especially in Missouri, we have mixed dockets in our jurisdictions, meaning that it is possible that there could be criminal cases going on sometimes with civil cases all on the same day and on the same time, or otherwise there'll be a criminal docket at 9 o'clock and there'll be a civil docket at 10 o'clock. And just recognizing that we're all human, and in the context of perhaps a judge who just went through a very difficult criminal docket coming in and saying, for me, I do more of the traditional commercial property, lender type issues, not receiverships, not in the healthcare space or like cannabis receiverships, which is an entirely different ball of wax. But saying that, hey, we're not getting paid on our loan documents, or we're worried that this commercial property is going to be in disrepair, and citing that as an emergency, even if there are, and of course there would be very good reasons for making those allegations if we were to make them, again, against the backdrop of a judge that just dealt with a horrific criminal docket, he or she might say, this is not an emergency. I just dealt with emergencies, and I just dealt with them in a very gruesome manner. And so you're going to have to wait until I can find a time to go through the pleadings and figure out what's really going on here. So again, I think that just goes back to being mindful of where you are and what judge will ultimately be hearing your application.
Fair. Paige brought up a good point just a minute ago about when considering the appointment of a receiver. You're obviously looking at the loan documents. Is everything lined up? Is your house in order? Taking a look at also what other creditors, lien holders are out there. Mark, what happens in situations in which your client is not the senior secured lender and you want to appoint a receiver?
So in those circumstances, typically good coordination with the senior secured lender is going to be necessary. Most of the time, if we're called in to represent MEZ, for example, we're going to be governed and bound by an intercreditor agreement or a co-lender agreement or something to that effect. So ensuring that you have the rights to act in that circumstance is going to be critical. All of this is contract and statutory based. So to the extent that your contract allows for it, then you go to the statute. If your contract doesn't allow for it, you still go to the statute and see if there's a workaround. The ways that you can typically circumvent this is if you have true life safety issues. So I don't deal enough with healthcare specifically to discuss in that realm, but the typical place where we see this is if there's fire safety issues, fire suppression issues, if there's a literal hole in the roof in a residential building, if there's been a fire, a flood, something else that's significant that's occurring, or frankly, during the COVID era when you had hotels that were rebranding and repurposing themselves as shelters, there were significant emergent issues that needed to be addressed in order to preserve the value of the collateral, but also to preserve life safety issues. As I'm sure you can imagine, it's challenging to kind of co-brand a Marriott where you have people that are expecting to show up and be in a hotel, and it is filled with it's filled with alternate people that are just now being housed there. So there were significant issues that popped up during that period of time that needed to be addressed with the courts. One other thing just to mention on our prior topic is mortgagee in possession. So I know we're talking about receivers and receiverships, but the last question was ways to not file a receivership. So in those circumstances, it's few and far between, but there's a concept of mortgagee in possession, where effectively the lender comes in and takes over the property, dispossesses the borrower of rents, issues and profits of the property, but doesn't actually appoint a receiver. Those circumstances are few and far between. The last one that we did were 2 surface lots in the city of Chicago that didn't really have much going on, and there wasn't a real basis to have a receiver there and to justify the expense. But mortgagee in possession can be an entire other CLE topic where we discuss all of the pitfalls of that. But I just wanted to throw that as a flag here as folks are listening in.
No, thanks.
I'll
Awesome.
add to that briefly.
Go ahead, please.
Again, just a slight twist because I'm in Missouri. So Missouri has non-judicial foreclosures. And so if the goal of your client or of yourself, if you are the client, is simply to sell the real estate, get the real estate off your books, and you're sitting in Missouri and your deed of, what Illinois calls mortgages, in Missouri we call them deeds of trust. If there's the power of sale language in your deed of trust, which there are in every single deed of trust that's written, that's worth the paper that it's written on, you can foreclose on a property once you get the title work in hand in 21 days. And so if that's all you want to do, you get the notices out, you schedule the sale, you go to the courthouse steps and you call the sale. And that's that. And so obviously that's going to be, if that's all you want to do and you just need to get the real estate off the books, it's going to be a much cheaper route than going through the receivership process. So that would be something kind of like Mark indicated, would be another reason why maybe a receiver wouldn't always fit the bill.
Okay. Sticking with you, Emily, how do you determine if the appointment of receiver is the least disruptive and most effective remedy?
I mean, I think it goes back honestly just to the decision tree that we've already talked about. I mean, you have to just look at what's the situation in front of you and what's the ultimate goal of the client. And if the goal of the client is to right the ship and to not necessarily liquidate the business, but just get it back on track, a receiver can be a great way to do that. If the client is looking to liquidate and maximize what they're going to ultimately receive in the liquidation of the asset, having a receiver could be a fantastic route, because potentially your receiver is going to be able to market this property nationwide if we're talking about like commercial property or something like that. So, I mean, I think it's just taking a good look at what is the situation and what's the ultimate goal. And then you couple that with, you need to pick the right receiver. And that's going to make sure that the disruptions are as minimal as possible. Because to Paige's point, if you have a receiver who's fantastic at handling commercial real estate receiverships, they likely are not going to have the skill set necessary to run a healthcare receivership. And so being aware of that and cognizant of that is important. The wrinkle comes when you have jurisdictions that have lists that you have to, mandatory lists, and you can only pick from this list, which I don't have to deal with because we don't have that in Missouri. But I think it's just looking at everything eyes wide open is what's going to be your best bet.
One of the real issues with Part 36 receiverships in New York is that the judges are now sometimes just choosing a different or an alternate receiver that can come in. And that obviously creates a lot of uncertainty for clients, which is not a good thing. So in New York and even in some other jurisdictions, to the extent that you have lists or you have the inability to really be able to point the direction of a receiver, that level of uncertainty is not ideal for the senior secured lender. But to Emily's point, choosing the right receiver is key. So making sure that the person has the adequate experience, et cetera, that's critical.
Well, we'll stick on that topic real quick. Paige, especially in the healthcare, I assume that you have a list of receivers that really specialize in, the healthcare type industry. What happens when you come across judges that really are like not as educated, or they have a list and you're like, well, wait a minute, this is an incredibly special situation. How do you navigate that? How do you deal with that?
Then the majority of your hearing on the appointment of a receiver educating the judge, particularly with healthcare. There's many reasons, right? The receiver is going to have to interact with the State Department of Health. They're going to have to understand the collection of very special receivables that have a lot of issues surrounding them. So I spend a lot of time educating the judge. It's also something that is part of our diligence going in, knowing that we're going to have the ability to have that conversation with the local bar. If we understand the local jurisdiction where it's not going to be a conversation, where it is, you need to just use someone on the list, we're probably not going to file a receivership there. And maybe that's one of the circumstances you have to look at. Is a bankruptcy better? Is in some other form of resolution here better? Because we're not going to be able to have someone to come in who's going to be efficient and is going to be able to handle this type of property. Is really the way we approach it.
Excellent. So when a decision is made to move forward with the receiver or receivership, Mark, what are next steps? What filings are necessary?
So in the vast majority of jurisdictions, you'll need a complaint to foreclose. And with that complaint to foreclose, you'll either seek additional relief within the confines of your complaint for the appointment of a receiver. in most jurisdictions, you'll file a standalone petition or motion to appoint receiver that's coupled with your receivership filing. As part and parcel of the receivership filing, you'll need to include the bona fides of the receiver, usually a fee schedule, so that the court and all parties in interest understand how the receiver gets compensated, and then typically include the individual receiver's resume and CV so that the court can evaluate the individual's credentials. Some states will allow you to appoint a receiver that's an entity. So for example, New Point would be the receiver. In other states like Illinois, an individual has to be the receiver. So Matt Brash would be the named receiver. And it's important to make sure that you have those distinctions and nuances down. Additionally, if it's going to be something where it's a large office building or a large hotel or anything like that, you're going to have property management that's going to sit potentially with or pari passu with the receiver. It's going to be important to know what the property management company is going to be charging, and so that that's not duplicative of what the receiver and the receivership fees are. And it's a lot of judges now are giving us some pushback when the receiver is also the property manager and is also the broker. And so in those circumstances, some courts are saying, hey, you need 3 different standalone entities for that because there's a conflict of interest. I don't necessarily agree with that. I can't fathom what the conflict would be if the receiver's goal and purpose is to maximize value for all parties in interest. That's also the broker's goal, because the broker will get paid more if the broker is able to maximize value for the property. They'll get paid more in their commission. So I don't necessarily agree that it's a conflict, but just understand that that is an issue that we're seeing pop up in more than one jurisdiction and in front of more than one court.
And Mark,
Webpage,
quick
please.
question on that. When you're seeing it, is it that your receiver order said that that entity could do all three positions, and the judges are saying that's a conflict? I won't grant that in your original receiver order.
Even if it's separate entities, so if it's XYZ LLC, XYZ1 LLC, and XYZ2 LLC, and each one is a different role within the receivership, if it's common ownership or unity of the individual that's going to be stepping up for each of those entities, we've had some judges in Illinois, in New York, in Indiana, in Ohio, I think, in some other regions that have said, hey, there can't be the same individual that's doing all of these things. You need to hire a standalone third-party property management company that comes in with a market rate proposal. Or you need to submit a bevy of brokerage proposals before I allow you to appoint a commercial real estate broker. So we've seen in different contexts, and not subject to any uniform state law, federal law, or anything, just judges that are coming in and saying, this isn't okay. We need to have separateness between all these entities.
Do you still find, Mark, that still can be a successful tactic, or you think it gets too many cooks in the kitchen, perhaps?
And what about
It's tough.
the cost to the receivership estate too?
That's exactly my argument, Emily. And it's so far, it's been successful most places.
Yeah.
So I think, as Paige mentioned earlier, it's educating the court. So when you're dealing with a lot of collar counties or other jurisdictions where you aren't necessarily seeing a ton of commercial foreclosures and a ton of commercial receiverships, sometimes it's really just an education piece. Other times it seems to be pulled out of thin air. And no matter what you say, from a logic standpoint, the answer is no, this is not how I do it in my courtroom. This is how it will be done. Here's what you need to do. And so in those situations, there's not much that any lawyer is going to say to be able to circumvent that. But I agree with you, Emily. It's a massive additional expense. And there's a lot of different voices in that discussion that, in my view, is unnecessary. The vast majority of the
professional fees. I mean, that's got to.
Yeah, it's duplicative. It's additional spin-up time. It's more legal fees for the lender, because now we've got to go and quarterback all of that with 3 different people, 3 different check-in calls, all kinds of different communication. No one's talking to one another, and it can create, I think, administrative roadblocks. But that said, depending on the size of the asset and depending on what the situation is, it's still a better option than simply avoiding or foregoing a receivership altogether.
Yeah.
Paige, do you run into it with healthcare, where you have your healthcare receiver in charge of obviously running whatever the center is, but then you want a property manager separate for the real estate component? Is there anything tied into that, or is it all under one umbrella?
It's usually two. So we usually have the receiver who's appointed, and then they employ a manager. And so I always have in the receiver order the approval of the receiver and the manager and their rates. I also typically do build into those orders that the receiver has the ability to market the property for sale. What we've done to, and in many instances, it does make sense to have a separate broker involved. And when we do that, what we do with the receiver's compensation is say, we'll make sure between the receiver and the broker that the total compensation charge for marketing these properties is market rate. So you kind of work together on the rates and have individuals that know what type of property is being sold and can work together. But we do see different buckets, particularly in the specialized areas, but then an ability to work together to make it efficient.
Excellent. Emily, the timing to get a receiver appointed, we have our thoughts and landmines and hurdles in Illinois. What do you see in your jurisdictions?
I mean, the act says 7 days notice time, right? But there's case law that came out last August 2023, maybe, that really has said, look, once, we see that there's, and this is from the Supreme Court, we note that there's 7 days notice in here, but really, once the parties get served with in Missouri, we call it a petition, is the opening lawsuit, opening filing. It can be a standalone, meaning that there doesn't need to be any other cause of action other than simply an appointment of a receiver. And Supreme Court said, look, I mean, once you've got service, you really do have notice that this is going on. So, to Paige's point, I mean, I've seen anything from, you can file and get in there very, very quickly, or the judge needs some time to look at it and kind of read through the act itself if he or she is not familiar with what a receivership is or with the act. In some counties in outstate Missouri, they have what are called law days, which I think other states have similar type days too, where the judges hear motions twice a month. And you get one of those 2 days and that's your day. And they're, again, likely not going to grant any special circumstances for you. And so you could file and maybe you're waiting for an entire month before you can even get in front of the court. So that's a long answer to say it's all over the board.
Paige and Mark, I know in state court and certain jurisdictions, and I know that in Cook County at one time this was kind of standard, but again, I haven't seen it too much recently where a borrower defendant got to ask for a substitutive judge at least one time and they'd have to honor that. I would think in healthcare that wouldn't fly as much because you're dealing with a very sensitive situation. And Paige, you said that you're able to pretty much prevail pretty quickly in those scenarios because of the sensitivity of it. Mark, are you seeing at all any of that shenanigans where it's a lot of this merry-go-round circus act of just delay?
It's lowbrow. It's pretty petty, and frankly, it's kind of coming into it once you see who's on the defense side, if that's a tactic they're going to take. Mm-hmm. My view is that it comes up more frequently in the consumer context, which we don't touch. And where you see that crossover is when you have consumer lawyers that are getting involved in a commercial dispute, and they come in with their typical consumer playbook where they try to merry-go-round on the judges. But yes, we've seen it. We've seen pretty unscrupulous opponents that have come in and taken a change for every LLC that we've named. They've then taken a change for each guarantor. And by the time you're done, you are round robin right back to the same judge. So it's very frustrating. There is, unfortunately, there's no way around this. It's each individual defendant has the ability to take a change as of right. And while it's not something that we condone or that we think very highly of, there's very little that judges are going to do to stop it. If it becomes an abuse and it becomes something where it's truly just the same person and they wait out every time they ask for a courtesy extension, that comes and goes. They then file a motion for extension of time. Then they take a substitution of judge. You can start to bring these patterns forward and effectively avoid additional delay. But again, those types of lawyers seem to be moving out of this practice on the defense side. And folks are really just coming to this in a more commercial way, saying, we understand we have an issue. We want to work with the lender at least to get this property stabilized and into a position where we can then effectuate a sale or a process to get this resolved. right now, as you can imagine, not a lot of buildings have a significant amount of equity, and the ones they do, they're trying not to get into foreclosure because they want to preserve that equity. So I think the strategy is changing a bit. But Matt, you're exactly right. I know that we have sat in the same courtrooms and watched the same attorneys take changes of judge for every single one of their clients, and it's a wildly frustrating tactic.
Paige, we talked briefly about recommending the receiver and the conflicts and professional background in industry. And is that receiver going to act qualified as neutral, which I still want you to go into a little bit more. But, I also really want you to talk about the appointment order, and especially with what you do in the healthcare, like how critical that is from the get-go. Because I'm sure once receivers are appointed, in all cases, especially, but I'm sure with healthcare, in a specific industry where you don't want the receiver to be kind of shackled to what he or she can or can't do and have to come back and continue to ask for permission to do that one more step. So can you kind of go into the receiver order and how critical it really is to setting the grounds and the path for which the receivership can be successful or not?
And you're absolutely right, Matt, that it's absolutely critical. I mean, it guides your entire case. I think it's your beginning opportunity to have all of your provisions that you really need in the document. So my standard to receiver order is probably almost 20 pages long. And everything in there is absolutely important. And I think most judges who read through it think it's very reasonable, right? You have all of the things that the receiver can do with collecting all the receivables for the property, with acting on behalf of the entity, with, dealing with creditors, all the important things, insurance. Some of the key provisions that, outside of just your general operations that I also like to have in there, deal one with the lender, right? So using the cash that comes in, I'd want a budget in place. And I want there's reporting to the budget, and that there's priority liens for any funding that come in, and that there's a cash management system in place, and that there's reporting on the cash that's being used. I think all of those are important to put in upfront so that you have a guide throughout the case on the operations. We also put in prohibitions on, current officers and directors and principals of the entity from being on the property, from taking any action with respect to creditors, from having any access to bank accounts. All of those kind of injunctive type relief provisions, I think, are really important in the order. And also, I always put in the orders a stay, right? You don't want creditors being able to sue your defendants in other litigation and try to attack the property. So we always put in provisions that prevent them from doing that. Now, when you're in state court receiverships and you have actions that are taking place in other states, that makes it very difficult to go through the enforcement process there. But if you're in federal court and you have a federal injunction over those actions, you have a lot better chance of enforcing it. Although I will say I had one in the last year where we had an injunction within our receiver order from a court here in the Northern District of Illinois and a state court in the southern part of Illinois that I don't care. I'm not I'm not following that order, and you can sue all you want. So it doesn't always hold up, and you have to kind of take it case by case and whether it matters or not. But it's important to have in there. And then, the final real big piece to me is what's the exit strategy? How are we getting out of this receivership? And I want that in my order so that we all have a plan of what we're doing and the ability for the receiver to sell the property, kind of along the lines as you do in bankruptcy of the 363 sale, but, setting out those provisions in the order. A lot of courts will make you come back and actually ask for approval for your sale, but setting out what's going to happen, I think, is important within the receiver order and gives the receiver comfort as to how the receiver is going to get out of the case.
Receiver and the judge, I think.
That's right, Emily. Yeah.
And Mark, I get calls on, hey, we're gonna want to appoint you as a receiver, and I think, let's say out of 10 calls that I get, maybe half or less go through only because the filing of that motion to appoint a receiver is what finally gets the attention of your borrower defendant. Talk about that leverage and, just by filing the motion, do you see that even in today, are you getting the attention of that borrower defendant, or, what are leverages that the receiver motion provides, or just the appointment of the receiver?
Absolutely. We always talk in points of when a bankruptcy filing might happen. And so when can you kind of get the ultimate trump card here where the borrower comes in, throws their hands up and says, we need an automatic stay. We're going to push this into a process. At the time of filing your complaint for foreclosure and other relief, that's one time to stop everything. Another big time that we see this happen is on the eve of the receivership hearing or sometimes minutes before. We've also had circumstances where borrowers will throw it in moments after the receiver is appointed to effectively dispossess the receiver from this property. So the long answer to your short question is it absolutely gets the borrower's attention. There's no way it can't, because if the property is cash flowing in any way, shape, or form, collecting money, all of those rents, issues, and profits post receiver order will get turned over to the receiver to hold for the benefit of all parties in interest and dispersed either to pay property expenses or ultimately sought to turn over to apply to the debt at the conclusion of the case. So it still carries a lot of leverage. You also, even absent a leverage point, it's a neutral third party. And so for everybody, for the lender, for the borrower, for the court, it's really a neutral person that comes in and can manage the property, can be honest and forthright with everybody about the situation, and making sure that everybody is kept in the loop as to what's going on, what specific tenant issues are there. Is there an industry issue for whatever you're dealing with? Is there a jurisdictional issue? Is there a regional issue where there's too many hotels in one pad, and so this no longer is viable as a hotel? You're able to have a receiver come in and report to the broader group to say, this isn't working in its current form, or it's working great, and there were just some administrative and management issues that needed to get stomped out. We needed to strip away a way over market property management agreement or something in order to stabilize the asset and get it into the hands of a bona fide third-party purchaser.
Great.
If I can just add a minute to that, Mark, one of the items you mentioned made me go back to my receiver order provisions, but I always also like to include a prohibition on filing for bankruptcy by the officers and directors. Now that's a whole nother presentation in itself about the and the issues with it, but I think it's really important to have in all of the orders.
Have you had to enforce that yet? Because I'd love to hear how that went.
Yes, I spent a lot of last year litigating that issue.
Lots of fun.
I think, Paige, we have a panel that you can moderate for next year's series. That would be such an interesting, fascinating topic to hear and talk about. As we're getting to the end here, Paige, I want to ask you about how receivership estate should be handling pre-receivership expenses versus post-receivership expenses. Scenarios in which pre-receivership expenses really do need to be paid because it affects the operations perhaps. But if you don't mind going into, because I know there's a lot of arguments out there and there's a lot of differentiation, between what a receiver should and should not be paying, because that is collateral of a bank or your client. And, you don't want to be paying down the debts of the borrower defendant.
You don't want to be paying down the debts, and you don't want to be favoring pre-receivership creditors one over the other. So the receivership order, in the one that my favorite language is that they won't be paid unless it's in the receiver's reasonable discretion that it needs to be paid and the lender approves. Because there are certain circumstances, you go into the healthcare world again, just because it's what I see so often, but sometimes if there's a food vendor that is the only food vendor available for this rural community, you don't have other food vendors that will deliver. Sometimes they need to be paid. Sometimes there's utilities that refuse to, we don't have the protections of the bankruptcy code here, and the utilities refuse to, that threatened to shut off electricity. I just had this in a home in Ohio where they needed to be paid the pre-receivership expenses. So I think it's few and far between where pre-receivership expenses are paid, but there are certain circumstances where they have to be paid to preserve the collateral, to preserve the health and welfare of whatever the business is to go forward. But I think receivers try to err on the side of not paying pre-receivership expenses, again, so that they are all treated equally with whatever money goes to those creditors at the end.
Thanks, Paige. Emily, can you talk about administrative priority expenses in a receivership? So those expenses that, receivers' fees, legal fees, any other professional fees. Do you mind touching on that and really it's the importance of it, and especially critical into going into a receivership, like those expectations?
Certainly. I mean, typically what you're going to see, or hopefully what you're going to be working under, is like in Missouri, our statute sets forth, these are the fees, this is the fee schedule, this is how these fees get paid, with the administrative fees being number one, which gives comfort, certainly to a receiver who's looking at taking on this matter. And I think the handling of those fees, that's where being very focused on what the language of your receivership order, that's where that really comes in, because you're going to put in that receivership order, here are the fees that we're expecting, here's how they are going to be paid, so that not only is the receiver comfortable with it, the court's comfortable with it, professionals that are going to be working with the receiver, management, attorneys, accountants, whoever that might be, understand how they are going to be paid and what their fees may or may not be subject to as far as scrutiny by the creditor or by other parties and interests in the case. And so, I think that's the answer to your question, but I agree with Paige, just with regard to the receivership order has got to be, I think, probably the most important document in the receivership, because that is really going to be your guiding light with all of these issues, and certainly with regard to the administrative fees that you're going to be dealing with.
So I think just a question for all of you. Have you found receivers? I mean, it's a loaded question, but for the general part, have you found receiverships to be more expensive than you anticipated, less expensive, cost effective? I know each one has got its own shape and size and a different sandbox that's played in. And sometimes you go in as a receiver, I go in expecting the unexpected, but sometimes the unexpected is a bomb that you weren't expecting walking into. Anything to that nature of what your overall general findings have been from a cost perspective?
Let me answer with a question. Is the lender using NewPoint and Matt Brash?
Excellent.
Because if that's the case, then there's never an issue. But all infomercial and kidding aside, yes, they can get expensive and things can get unwieldy. Where I think things go off the rails, as with anything, is if there's a lack of communication between the vendors. So if, for example, the receiver is not reporting to the court with any type of regularity, that's a problem. Some jurisdictions don't require reports, which I find to be shocking. But there are some jurisdictions and some courts that say, we don't care, we don't want to see your reports, just come in if you have a problem. That's really where things can start to sneak under and become an issue. The other place that we see there being major problems is if you have a kind of gross rents fee. So if, for example, it's a large office project and you're charging some percentage of rents collected at the property, those fees can get pretty significant pretty quickly. And I think a lot of courts are pushing back on that and saying, is this really justified? And to that, I say, representing receivers in that capacity, yes, it's absolutely necessary. Absent our excellent work, these rents wouldn't be here for the benefit of anyone anyways. So I think as long as your lender client is aware that receivers are a cost, it's not free. No one is doing this for the kindness of their heart. Everyone is going to be compensated, but understand that it needs to be for the benefit of the property. Then I think typically folks are okay with it. There are cases in the rare circumstances that drag on for years and years for a variety of reasons. Typically, it's lender driven for certain reasons. They can't get certain phase environmental. They don't know if they want to take title. There's issues with the exit for this foreclosure process. In those circumstances, receiverships can be ballooned from an expense standpoint, and that can create issues. So it's just important to really make sure that you have a plan before you just go and throw in a receiver.
Paige and Emily, some final comments, thoughts as far as one, the question I just asked, but two, just your general getting a receiver appointed, the whole step and process.
Yeah, the only thought I have is that, sometimes the receivership is really the only route you might have. I mentioned like cannabis, and you're not filing bankruptcy if you're dealing with the cannabis. And it doesn't just mean like your client or the cannabis company. I mean, it can be, federal courts are very hesitant still. So that if it's anything that touches that industry, that the court might say, look, you can't come into bankruptcy court. There's some loosening of that, I think, up in the Northeast and perhaps out in California, where judges are getting a little bit more lenient. But I think, and you also got to think about the industry that you're in when you're looking at a receivership. And we didn't talk about that today, but I think it's something to keep in mind.
Paige, any final comments, thoughts?
Two quick things. One, with respect to costs, while they can become unwieldy, there is a cost depending on the actual operation. I do think in the end, a receivership for the right entity and situation is much cheaper and efficient than a bankruptcy. Bankruptcies are really expensive these days, and there's a lot of costs that go with them. So receiverships usually are the more cost-efficient option for all creditors involved. And two, I just wanted to talk quickly, just kind of a point for food for thought for people in going back to when we actually file our receivership complaint. One of the things we didn't get to get into today with all the good things we talked about was service of the complaint. And
Absolutely, please go into it. Yes.
Seen recently from a title company on a foreclosure case is that they were not willing to give title to our borrower because when the order appointing the receiver was entered, which was done very quickly in the case, the defendants had not yet been served with the complaint. And they claimed that because of that, there was not jurisdiction over the defendants when the receiver order was entered, and therefore that title company was not going to insure the property for the buyer. And so it's extremely important to, one, understand each state and what is required there, but then also when you're working to find title, sometimes you need to work with different title companies to address that, and also just kind of thinking it through in the outset of the case of the issues you may deal with several years down the line.
Excellent. Well, I'd like to thank Emily and Paige and Mark for this excellent panel. I know we could probably talk for a couple more hours, and there are so many other things that we can bring into it, but we only have a certain amount of time here. I don't know if we have any questions, Michael, or not, but before that, I just want to quickly say thanks again to our co-producers and co-sponsors, Daily DAC, Max Asset, the National Law Review, and Financial Poise. We have a couple more panels, webinars coming up over the next couple weeks. Next week, we have how to administer receivership. May 21st, we have an asset sales in receivership. And then on May 28th, we're going to talk about how to conclude a receivership. So I want to thank again, Emily, Paige, and Mark. Thank you to Financial Poise. Thank you to Michael and Priscilla and Julia and Jonathan and the entire staff. We really appreciate your time, and thank you so much for this opportunity. And hope everyone has a great day.
Thank you, Matt.
Thanks,
Matt.
Thank you.